making process under the Administrative Procedures Act. But it was guidance that was issued, and it was enforced by the Department of Education under the threat of withdrawing federal funds. All right, so the guidance was fairly compelling guidance, and it was aimed a lot at colleges and universities, and it was intended to change the campus culture. So there was a campus culture that involved a lot of sexual activity, alcohol, and date rape, for example. So colleges and universities were under a lot of pressure to institute new procedures dealing with trying to change that campus culture. And the new procedures involved how you would investigate claims of sexual harassment or sexual assault on campuses, and how you would prosecute them. The Trump administration came in and eliminated a lot of that Obama-era guidance because it was just administrative guidance. And instead, what the Trump administration did was they went through the rulemaking process. So we've now had 3.5 years of the Trump administration, and this rulemaking process has been going on for a good chunk of that 3.5 years. It takes a long time to go through this rulemaking process. The rulemaking process, for example, you go through and you issue preliminary rules and you take comments on it. The Department of Education took more than 124,000 comments on these rules. OCR's explanation of these rules is more than 2,000 pages long. We were dealing with a matter that we were trying to get the answer to, and I found it in footnote 209. Okay, so it's an awful lot, and it's very involved. And so the new regulations went into effect this past Friday, August 14th, 2020. They make major changes from the Obama-era guidance. There are new processes for handling formal complaints of sexual harassment. There are new requirements dealing with notices, training, and record keeping. You need new board policies, and they're on your agenda for first reading tonight. We're going to change that to first reading for the board to consider. And the policies are designed to more closely align with two major U.S. Supreme Court cases that came out in 1998 and 1999. We're going to talk about those in just a minute. So those are the big highlights for what we're going to be talking about. Now, there are 4 pending lawsuits that involve a wide variety of different plaintiffs. For example, one of them involves the attorneys general from 17 different states. There are 4 different federal lawsuits that are requesting injunctive relief. In 2 of those cases, the injunctive relief, that is a request to stop the Department of Education from implementing these new regulations, that was denied. In 2 other cases, it's still pending and the requests are there to enjoin or overturn these new rules. I don't personally think they're going to be successful. Those lawsuits are going to be successful, but there are still 4 pending lawsuits. So you'll see I've got a stop sign with a question mark there as to whether or not these rules will be enjoined from being enforced. All right, so in 1998 and 1999, the U.S. Supreme Court decided 2 different cases that set forth the standard for liability on the part of a school system in different circumstances. And the first of these cases, Gebser versus the Lago Vista Independent School District in 1998, Alita Gebser was a student, and she had an affair with one of her teachers. And they were eventually caught, and the teacher was immediately no longer employed. And eventually she sued and said that the school system should be liable for damages under Title IX because she was sexually harassed during school in violation of Title IX. All right? And the court in this case, the U.S. Supreme Court in this case, said that the school district is liable for harassment. They set the standard for liability here, and they said the school system is liable for harassment when it meets these 2 elements. One is that it has actual knowledge of the allegations by an appropriate person. An appropriate person is someone with the authority to do something about it. Okay? And second, that the school system responds to the allegations so deficiently that it amounts to deliberate indifference. Okay? Now, the next year, they dealt with another case of sexual harassment, but in this case, instead of it being a teacher and a student, it was student-to-student sexual harassment. And in that was the case of Davis versus the Monroe County Board of Education. The mother of LaShonda Davis, who was an elementary school student, reported to school officials 8 different times during the course of 1 year, different allegations of boys harassing her daughter. And the school officials did not respond as you might have hoped school officials would respond to this. And in this particular case, the court set out a different standard for liability in peer-to-peer sexual harassment cases. And they said that the district is liable for harassment when it has actual knowledge by an appropriate person. That is, somebody has to know about it, first of all. Second, that it responds with deliberate indifference. And on top of that, the harassing conduct was so severe, pervasive, and objectively offensive that it denied the victim equal access to educational opportunities or benefits. So it actually has to interfere. It has to be severe enough and persistent enough and objectively offensive. Now, objectively offensive means it would be offensive to anybody reviewing that, any reasonable person, not just that the victim of the harassment was thin-skinned and found it offensive. Okay, so objectively offensive means it's not just the victim who found it offensive, but any reasonable person viewing this would consider it to be offensive. Okay? And it also has to deny the victim equal access to educational opportunities or benefits. All right? So those were the 2 standards of liability. So we've got the new regulations that just went into effect on Friday. What's changed? Well, the final regulations make a number of changes that are intended to narrow the definition of sexual harassment from what it had been expanded to between the 1998 and 99 court cases and under the Obama era guidance, and to try to sync that definition more closely with the holdings in those 2 Supreme Court cases, Gebser and Davis cases. There are 3 different types of prohibited sexual conduct. Quid pro quo conduct, we're going to talk about that we're going to talk about all these in just a second. Quid pro quo is the exchange of one thing for another, okay? Second is unwelcomed conduct, and third now is a new category of conduct that is prohibited under the Clery Act and the Violence Against Women Act. So we're going to talk about those beginning right now. Okay, quid pro quo was really easy to understand. It's when a school employee conditions access to educational benefits on unwelcome sexual conduct. Okay, here's how you can get an A. Okay, do you want to pass my course? It's pretty easy to understand. And this provision applies only to employee conduct. Now, look at that third category. It's on unwelcome sexual conduct. You can say, suppose it's a consensual affair between a teacher and a student. Well, a student doesn't have the ability to give consent, okay, under these regulations and under the law. So it can't be a consensual affair. So it is always going to be interpreted as unwelcome sexual conduct if it's sexual conduct. All right? So that's easy enough to understand. Quid pro quo is the exchange of one thing for another. It's like, whoops. All right. Let me get back to these. Come on. I'm going the wrong way, sorry. All right, sorry. My clicker finger got crazy here. There we go, okay. So this is, crap. There we go, okay. So this is, don't you worry that withholding cookies until I clean up my room might constitute an illicit quid pro quo. All right, that's withholding a benefit until you do something I want you to do. Okay, so that's quid pro quo. All right, next is unwelcome conduct. So the old definition was of unwelcome conduct was it had to be determined by a reasonable person, and it had to be sufficiently severe, persistent, or pervasive to limit a student's ability to participate in or benefit from the educational program, activities, or other school services. The new definition that just went into effect is, again, it's unwelcome conduct. So the first thing is unwelcome conduct. Let's talk about that for a second. Mutual flirtation is still allowed, okay? So if it's mutual flirtation, that's allowed. If it's welcomed, all right? So if, for example, I'm flirting with Ms. Balance and she's flirting back at me, okay, that's okay. You know, our spouses may not think so, but, you know, but if it's welcomed by both of us, that's okay. It's not illegal, okay? It's not crossing the line, all right? But if I'm flirting with her and I think it's okay and she doesn't, then I'm running the risk, okay? So the welcomer runs the risk that the welcomee may not be welcoming it, all right? So I got to be really careful, all right? So I didn't mean anything by whatever I said, okay? I got to be really careful. So it's unwelcome conduct, but the determination of whether it's welcomed or unwelcomed is made by the welcomee, okay? The person to whom the flirting is directed, or the conduct or behavior is directed. So it's unwelcome conduct, but it has to be determined to be unwelcome conduct or inappropriate conduct by a reasonable person. So if I say, for example, to Ms. Balance, you know, that's a really pretty dress you're wearing, and I don't mean anything by it other than it's a pretty dress, and she takes offense at that, most people wouldn't think that was unwelcome conduct. They wouldn't think I was sexually harassing her, okay? Now, sometimes it depends on how you say it's a nice dress. You know, if I say, for example, to somebody, you know, that's a really nice dress, or if I say, whoa, you're hot and smoking in that dress, it's a different expression, okay? And I wasn't directing that at anybody. I'm just saying if I said that, okay? All right, so it has to be determined by a reasonable person to be something that is unwelcome conduct, and it has to be also so severe and pervasive and objectively offensive that it not only limits a person's ability, but it effectively denies a person equal access to an education program or activity. So that's going a couple of leaps beyond the old definition in terms of finding liability for unwelcome conduct. It has to basically effectively deny the ability to effectively participate in an education program or activity. All right, and then the third set of new prohibited behaviors are behaviors that are under both the Clery Act, which is a federal law that requires colleges and universities to disclose information about crime and violence on campuses, doesn't apply K-12, or definitions under the Violence Against Women Act. Now, these are the offenses that are defined in Clery and the Violence Against Women's Act that are now specifically included as forms of sexual harassment. Sexual assault, as defined under the Clery Act, and dating violence, domestic violence, and stalking, as defined under the Violence Against Women Act. And they are basically what you would expect them to be. Okay, they're fairly self-explanatory. I'm not going to go into detail on those definitions. So, when must schools respond to allegations of sexual harassment? Well, the school has to respond when it has actual knowledge, that's the language in the regs, of sexual harassment that occurred or is occurring in the school's education program or activity. Not Friday night at a party someplace, all right? But it has to be in a school's education program or activity for us to be responsible. And we have to have actual knowledge. Now I'm going to talk about actual knowledge quite a bit here. Well, we're going to start talking about it right now. What does this mean, actual knowledge? It means a mandated reporter has notice of sexual harassment or allegations of sexual harassment. The old rule said that we had to respond when we knew or should have known about sexual harassment. And that should have known was problematic. Okay? When should a school have known about something? Okay, that was problematic in a lot of cases. How do you figure that out? Okay, what were the clues that get to the point of you should have known from these clues that something was going on? The new rule is different. The new rule says that a school that has actual knowledge of sexual harassment in a school program or activity must respond promptly and in a manner that is not deliberately indifferent. So actual knowledge means, going back to the first thing, a mandated reporter has notice of sexual harassment or allegations of sexual harassment. The new rule says every single school employee is a mandated reporter. So what that means is any school employee who has not notice of any allegations of sexual harassment is mandated to report it. This covers cafeteria workers, bus drivers, coaches, teachers, central office administrators, substitute teachers, everybody you've got. And it also means they've all got to be trained, that they are mandated reporters. And if they have any idea of this, if some kid comes up to them or somebody comes up to them and says, look, you got to promise not to tell anybody, but I've got to tell somebody this, okay? You can't promise not to tell. Or if you do promise, you got to break your promise and tell. All right? If you don't, then their knowledge, the knowledge of a mandated reporter, is imputed to the school system for liability purposes. If a mandated reporter had knowledge and didn't bucket up the chain, we're responsible for that. School system's responsible. Okay? So now it's, if anybody knows, you've got to tell, and then the school system has to respond promptly and in a manner that is not deliberately indifferent, because we have actual knowledge as soon as a mandated reporter knows something. Okay, so Joe's asking, how do we report that the employees are trained? We have to go through training requirements, and we have to keep a record of employees being trained in that. Okay, so there are different modules. We're putting together training modules that will allow employees to click through and, you know, get an understanding of what the responsibilities are, click through, and we'll have a record of it, showing that they took a quiz and knew what their responsibilities were and that sort of thing. All right, so actual knowledge of sexual harassment has to be in the schools. Oh, sorry about that. I got too many buttons here and a bad thumb. Okay, so it has to be in the school's education program or activity. Okay, so reporting sexual harassment, who reports when and to whom, and how. So reports of sexual harassment can be made by anybody, not just a mandated reporter, not the alleged victim. It can be made by anybody. Somebody out in the community can make a phone call. Reports can be made by phone, mail, email, carrier pigeon, anything that gets the job done and gets a report to the school system's Title IX coordinator, who receives the report, and they can be made at any time, including non-business hours. Okay, so anybody can make a report of sexual harassment. The harassment has to be in the school's education program or activity, and the program or activity is defined to include locations, events, or circumstances over which the school exercised substantial control over both the respondent is the alleged perpetrator, and the context in which the sexual harassment occurs. Okay? And we are only responsible for allegations of discrimination or harassment that occur in the United States. So, for example, if the Spanish Club takes a trip to Barcelona and there is clear-cut sexual harassment that occurs in Barcelona, it's not covered under Title IX. Now, you could elect to make that covered under your board policies. That's a choice the board has to make. And there are a lot of choices that you would have to make when you adopt the new board policies, okay? But it's not a free-for-all. You know, you could say, nope, if you go to Barcelona, it's a free-for-all. You're not covered under Title IX, and the board's not covered under the board policies. Or you could say, that's an educational program that's part of the school system, and we're going to make sure it's covered under our board policies, whether it's covered under Title IX or not. Okay? Deliberate indifference. So a school can't be held liable for failing to respond to known allegations of harassment unless we act with deliberate indifference. Can you all see the screen okay, or can we shut the lights out? Are you following along on that too? Can you kill the lights on this? Okay. So the old standard was we could be found liable if the school did not take immediate action to eliminate the harassment, prevent its recurrence, and address its effects. The new standard is that we are considered to act with deliberate indifference only if the response was clearly unreasonable in light of the known circumstances. So it's again a much tougher standard to meet for liability purposes. Okay, clearly unreasonable in light of the known circumstances amounts to deliberate indifference. So if we respond in a way that is not unreasonable, or just unreasonable but not clearly unreasonable, whatever that means, all right, we're not going to be found liable. It's not going to be deliberate indifference. All right, so it's a much higher standard in terms of liability purposes. All right, so throughout the terminology in the rule and the terminology in the board policies that you're going to be considering, we have two different terms that you have to know. Complainant is the alleged victim. It's not somebody who makes a report. It's not somebody who makes a complaint. It's only the alleged victim. And a respondent is the alleged perpetrator. Okay, so when we're talking about complainant and respondent, we're talking about the alleged victim and the alleged perpetrator, respectively. It is not complainant is not a third party who reports allegations of sexual harassment, and it's not the Title IX coordinator, even if the Title IX coordinator is the person who signs a formal complaint. We're going to talk about formal complaints in just a minute. All right. So those are the terms that we use throughout the remainder of this presentation because they're the terms in the regulations and they're the terms in the board policies. So we're going to go through the process now of what you do when you get a report of sexual harassment, and you're going to see that it gets really elaborate. And you've got a lot of board policy to consider in order to implement these regulations. So the first thing is a report. And we have a formal complaint and we have a report. The report comes before a formal complaint. So a report of sexual harassment, including sex discrimination, can be made by any person at any time, by any means. They can show up on your doorstep, they can make a phone call, they can send an email, whatever, okay? By any means that results in the Title IX coordinator getting the report. Okay, if it lands in the Title IX coordinator's box, she's got it, okay? So does everybody know who the Title IX coordinator is? Okay, all right. So almost everybody looked at Sandy Kinzel, but nobody said her name, so I don't know how confident you were. Okay, what's that? Okay, so Sandy Kinzel is the Title IX coordinator. Congratulations, Sandy. All right, there she is. Okay, you can say she's got the laser on her now. Okay, it's right there. Okay, the target's on her. The report is not limited to the school's campus community. It can come from anybody. Okay, as I mentioned. School employees, however, have an immediate responsibility to notify the Title IX coordinator of any report or allegation of sexual harassment, and this applies again to any and all school employees, right down to substitute teachers. All right, so they've got to get training. When she gets the report, the Title IX coordinator has to do a number of things immediately. Well, the regulation says promptly. Okay, so here's what the Title IX coordinator has to do. She has to contact the alleged victim, that is the complainant, if that person can be identified, offer the complainant supportive measures, and we're going to talk about supportive measures in a minute, explain how to go about filing a formal complaint, and explain that you can have supportive measures even without a formal complaint, and also consider what the alleged victim, the complainant's wishes are with regard to supportive measures, and contact the alleged perpetrator, that is the respondent, and offer the respondent, the alleged perpetrator, supportive measures. So Let's stop at that for a second. Okay, a lot of people say, wait a minute, we ought to offer supportive measures to the alleged perpetrator? Well, that is indicative of a big shift in these new regulations. Okay, and the big shift, one of the big shifts in these new regulations is you have a presumption of innocence, and that presumption of innocence stays all the way throughout this process until you get a decision at the end of the investigation, as we'll see. Okay, so throughout this process, the alleged perpetrator now is given a lot more rights than under the previous guidance that was issued by OCR before. All right, so the alleged perpetrator, the respondent, gets offered supportive measures, and if supportive measures are not provided to a complainant, the alleged victim, we have to document why we did not provide those supportive measures and why not providing those measures is not considered deliberately indifferent. So, for example, the Title IX coordinator would have to document, I met with the alleged victim, the complainant, offered the following supportive measures, discussed how they could be implemented. The complainant said she didn't want anything to do with those supportive measures. She didn't feel like she needed them. I reiterated that they would be available at a later time if she changed her mind. And then should add a sentence, under these circumstances, the failure to provide supportive measures to the complainant is not deliberately indifferent. Okay, so. No, a minor could sign something under these, yes, yeah, yep. Okay, so responding to sex discrimination complaints, you have a formal complaint versus a report. Okay, so the next step is moving to a formal complaint after you get a report. So, oh crap. Here we go. All right, so the formal complaint is a document that's filed by a complainant or signed by the Title IX coordinator. So the Title IX coordinator can initiate a formal complaint even without the complainant, the alleged victim, initiating a formal complaint. All right? And it is a complaint that alleges sexual harassment against a respondent and requesting that the school investigate the allegations. Only individuals who are participating in or attempting to participate in the education program or activity of the school may file a formal complaint. So, an outside person, a parent, could not file a formal complaint. It's only the person who is participating in the education program or activity who can file the formal complaint. It may be filed with the Title IX coordinator in person, by mail, or by email, or by using the contact information that's required to be listed for the Title IX coordinator, or by any other method that's designated by the board in the board policies that you're going to consider. It has to contain, the formal complaint has to contain the complainant's physical or digital signature, or otherwise indicate that the complainant is the person filing the formal complaint. And at that point, that triggers the school's grievance process. We have to go under the new board policies that you'll be considering.
Rich, quick question. So you and I talked about this a little bit, just informally. But so the formal complaint will come on a new form that's being developed based upon the law. Yet you then move into, when you move into the grievance process, the Board of Education has a grievance form that has to be filled out. Are we doing both? Or is the formal complaint form going to take
Forget the old board grievance process, okay? This is a new grievance process.
Even in grievances that are not sexual harassment related or sex discrimination related? Just flat out new grievance process?
No, you're going to have a new grievance process that only relates to these Title IX complaints.
Okay, that's what I thought you.
Okay?
Right.
The old grievance process will still be in effect for everything else.
Okay.
But the new grievance process will only deal with these new Title IX complaints. Okay. All right, I mentioned supportive measures. The Title IX coordinator has to offer supportive measures to both the alleged perpetrator and the alleged victim. So under the old standard, we were required to use interim measures to help the alleged victim maintain equal educational access to the educational programs or activities. Under the new process, again, remember, innocent until proved guilty. So both the alleged victim and the alleged perpetrator maintain access to the education programs or activities. Okay, there's not a presumption of guilt, there's a presumption of innocence. So under the new standard, we can offer individualized services as long as they're reasonably available. They have to be non-punitive, non-disciplinary, and not unreasonably burdensome to the other party, and designed to make sure that both sides have equal educational access, and we're protecting their safety and deterring sexual harassment, ongoing or continuing sexual harassment. So some examples here are we could offer counseling, again, to either or both parties, the alleged victim or the alleged perpetrator, the complainant or the respondent. Extend deadlines or other course-related adjustments. We can modify work or class schedules so that they're not unduly burdened, they're not passing each other in the hall, they're not in the same class, that sort of thing. We could assure security and monitoring of certain areas of the campus where sexual activity or sexual harassment is alleged to have occurred, or other similar measures. But the supportive measures have to be offered regardless of whether we get a formal complaint or a report. So even if it's not reduced to a formal complaint, if it's just a report, the Title IX coordinator has to offer supportive measures. A supportive measure that completely removes an alleged perpetrator or respondent from an activity except for emergency removals, we'll talk about that in a second for students, or administrative leave for employees would likely be considered punitive and not allowed. Okay? So if it's a complete removal, it's probably going to be considered punitive.
Question.
Yeah.
So if, let's say in the example of supportive measures, that counseling is one of the supportive measures, and there's a need to go beyond a typical school guidance counselor, if it's a student, it could be a staff member, and or EAP program, where our adults can receive counseling services. Mm-hmm. If it's beyond that, let's say, God forbid, a child situation where a family is stating that they want to have a psychological evaluation done, or some clinical evaluation done that's outside of the scope of what we can provide in the school system, is the school system responsible for picking up the costs of those evaluations?
Okay, two things to determine that answer. One is it has to be reasonably available, the supportive measure, as a service. And second is you determine what's reasonable on a case-by-case basis.
Okay. Based
on the facts in that case.
Okay.
Okay? So, let's talk, I told you, just mentioned emergency removal. An accused student can be removed from an educational program or activity on an emergency basis. Okay, so if it's really a dangerous situation, we can have an emergency removal. But if we have an emergency removal like that, here's what we have to do. The school has to conduct an individualized safety and risk analysis and determine that there is an immediate threat to the physical health or safety, not the mental health, but the physical health or safety of a student or other individual that arises from these allegations of sexual harassment, and that this immediate threat justifies removal from the educational program or activity. So it's a high bar. That is, there's immediate danger, physical danger, okay? And then the accused student must be provided with notice and an opportunity to immediately challenge that decision, immediately following the removal. So they get notice of the immediate removal, and immediately following their removal, they have the right to challenge that. They can appeal it.
What logistically does that look like? A meeting with the principal where a student and his parents have a chance to come in and challenge?
That'll be in the board policies to be considered.
Okay.
Okay? So that's another choice the board's going to have to make as to what that looks like. All right? For employees, the final regulations don't limit the ability to put an employee on administrative leave pending an investigation. Okay? And whether that leave is paid or unpaid is left up to the school system. We'd still have to follow our state law dealing with suspension with pay or suspension without pay. Okay, but it's left to the discretion of the school system. Now, another thing to consider in here is, suppose the kid has an IEP or a 504 plan, or suppose the individual that we're dealing with is protected under the Americans with Disabilities Act. So if they've got any kind of a plan or protection, or a disability is implicated in any way dealing with the behavior that's involved, or the removal of the person, we could have a change in placement, for example, under an IEP. So if we're having emergency removal of a student who's got an IEP, that would be a change in placement. We'd also have to go through the IEP process. All right, and we'd have to have a determination under, whether the behavior was the result of whatever their category is that got them on the IEP in the first place.
So is this creating in employee situations another category of administrative leave versus suspension with pay or suspension without pay?
No, unless the board puts that in policy and creates another category. Okay. All right. So once you get a formal complaint, what does the Title IX coordinator do? Well, Title IX coordinator's got to do a lot. First of all, Title IX coordinator has to provide written notice of the allegations to both sides, okay, the alleged victim and perpetrator, and this is what the notice has to include: sufficient details to let the parties prepare for an initial interview. They have to be provided in advance of any meeting or interview or hearing that's conducted as part of this whole process. They have to be provided this. They have to include a statement that the respondent is presumed innocent, that is not responsible for the alleged conduct, and that a determination regarding responsibility is made at the end of the grievance process. Title IX coordinator has to inform the parties that they may have an advisor of their choice, and that can be, but is not required to be, an attorney in any meeting or interview that's part of this investigative process. They're entitled to a representative, okay? The parties have to be notified that they can inspect and review any evidence that's been collected, and they have to be informed of any part of the code of conduct that prohibits knowingly making false statements or knowingly submitting false information during the grievance process. So they have to be told that if you lie during this grievance process, there can be consequences, and here's what the consequences may be. Sandy. Right, right here.
Are they allowed to participate in this?
Yes. Yep. The advisor is allowed to be there and participate to the extent that is appropriate. Okay?
More than just your typical observer.
Right. More than your typical observer. Okay. 2 is Title IX coordinator has to investigate and adjudicate the complaint using a grievance process that complies with the final regulations. That's not your current grievance process. That's a new process that will be in the new board policies.
Are there any restrictions, Rich, back to the 5th bullet point down about evidence, about access to evidence? So typically when there's an investigation, in this case, there's a report that's made, which could be a document. There's the formal report that's done, that document. There are investigative notes.
They would have access to investigative notes and all materials that are part of the investigation.
Okay.
Yep. All right. So the regulations say that an institution may not impose discipline on a respondent, that is an alleged perpetrator, without going through the grievance process. So we can have an emergency removal, but we can't impose discipline until we've gone through this new process. All right, what about formal complaints being dismissed? There are circumstances where we're required to dismiss formal complaints and other cases where we may dismiss formal complaints. So an institution has to dismiss a complaint if the conduct that's alleged in the formal complaint would not constitute sexual harassment, even if it was proven, okay? Second, if the conduct did not occur in our education program or activity, it occurred at a party on Friday night, okay? Or third, it did not occur against a person in the United States. We must dismiss a complaint under those circumstances, okay? Additionally, we may dismiss a complaint where the complainant, that is the alleged victim, tells the Title IX coordinator in writing that they want to withdraw the formal complaint or the allegations. Or if the respondent, that is the alleged perpetrator, is no longer enrolled or employed by the institution, or if specific circumstances prevent us from gathering evidence sufficient to reach a determination regarding responsibility. That is, the allegations are about something that happened 2 years ago and nobody's got any evidence, and it turns out to be one side says one thing, the other side says the other thing, and we can't gather enough evidence or information to make a responsible determination.
So, Richard, the one where the respondent is no longer enrolled or employed is a jurisdictional issue.
Yeah, it's a jurisdictional issue, okay? So if they're not involved in our educational program activity, they transfer to a private school or a charter school, or they just withdraw, or they're homeschooled, or they resign if it's an employee, then we don't have jurisdiction any longer. What's that? At that point, no. Under those circumstances, we may dismiss the complaint, okay, at that point. Now, that doesn't necessarily relieve us of any obligation to help out the alleged victim if we've made a determination, all right? We must provide the parties with written notice of a dismissal, whether it's mandatory or discretionary, and explain the reasons why it's being dismissed. And keep in mind that even if we've dismissed a complaint under Title IX, that doesn't prevent or preclude us from acting under the Code of Conduct or some other policy to address whatever the issues or concerns were. All right? It only addresses the specific Title IX complaint. And dismissals can be appealed by either party. Okay? Even the alleged victim can appeal a dismissal and say, no, I want you to investigate and clear my name. Okay, the alleged perpetrator, I mean. Okay. All right. So let's talk about the grievance process and what's required in this new Title IX grievance process. We have to make sure that our process is consistent, transparent, and does these things. First of all, it has to treat both sides, the complainant and the respondent, equitably, and there can be no credibility determination based on or because of a person's status as an alleged perpetrator or respondent or an alleged victim, the complainant. So, for example, my firm had a case involving Duke University a few years ago, several years ago. And Duke had some training materials for their hearing panels for these things, for these kinds of hearings, that said that in 98% of the cases where a victim claims she was raped, they're telling the truth. There is nothing to support that. No research anywhere to support that. Okay? It's a pure myth, but it was in their training materials. Now, if that's what they're using to train their hearing panels, what does that do for the presumption of innocence? Okay, pretty much throws it out the window. It's just sentencing time almost. All right? So there can be no credibility determination made based on the fact that the person is an alleged victim or an alleged perpetrator. The new policy has to, the grievance process has to require an objective evaluation of all relevant evidence, both inculpatory and exculpatory. That is, evidence that would tend to convict and evidence that would tend to acquit somebody, to prove that they did it or prove that they didn't do it. The Title IX coordinator, investigators, and decision makers, and anybody dealing with an informal resolution have to be free from conflicts of interest and bias, and they have to be trained to serve impartially without prejudging the facts at issue. So we have to have separate training for the Title IX coordinator, the investigator, anybody who's facilitating informal resolutions, any decision maker, and anybody dealing with the appeals processes. They have to be trained on anti-bias and free from conflicts. The process, yeah.
Can the Title IX coordinator and the investigator be the same person?
Okay, the Title IX coordinator and the investigator have to be different people. Okay? The process presumes the non-responsibility of respondents until the conclusion of the grievance process. There have to be reasonably prompt timeframes for carrying out this process, and we have to inform all parties of critical information about the procedures, including the range of remedies and disciplinary sanctions we may impose, the standard of evidence to be applied, and I'll talk about that in a minute, by the district to formal complaints, and the appeals procedures, the range of supportive measures available. That has to be explained to both parties. Now, we also have to protect any legally recognized privilege from being pierced during the grievance process. So attorney-client privilege still applies. The guidance counselor privilege still applies, okay? And can't be pierced as part of this process. It's statutory. I want to go back to this one thing. The standard to be applied for conviction. The board has a choice under the federal regulations, but the board has to make a choice of what the standard of proof is going to be. And the standard of proof can be either the preponderance of the evidence. Okay? Now, preponderance of the evidence is a term that gets thrown around a lot, and a lot of people aren't sure what it means. But, you know, before you can convict this person, you have to find by the preponderance of the evidence that they are guilty. That sounds like a lot, right? The preponderance of the evidence. It sounds like a lot. The preponderance of the evidence is, if you think of the scales of justice, it's 50% plus a feather is the preponderance of the evidence. The greater weight of the evidence is all it is, even if it's a feather, okay? Or the other standard is clear and convincing evidence, which is a notch below proof beyond a reasonable doubt, which is the standard to convict in a criminal court, okay? So you're gonna have to make a decision. Are we gonna find people guilty of sexual harassment based on the preponderance of the evidence, greater weight of the evidence, or are we gonna require that it's clear and convincing evidence? Okay? So that's a choice you have to make in the new policies as to the standard to be applied. So we're gonna have inconsistent decisions made by school boards throughout the land on this. All right? But that's
Is that
a choice
one of the
that's
arguments why they're trying to overturn this?
left. Say what?
Is that one of the arguments?
That is
why
one of the
there's
arguments.
an attempt to overturn?
Yep, that is one of the arguments in the lawsuits. Yep, is that's going to result in, or that's going to lead to arbitrary and capricious results, and inconsistent results. All right. When investigating a formal complaint and throughout the grievance process, we have to do these things. These are the responsibilities of the district. We have to make sure that the burden of proof and the burden of gathering evidence remain on the district. It's not up to one of the parties to prove that it happened or that it didn't happen. It's our responsibility to gather the evidence, and we carry the burden of proof. We have to provide an equal opportunity for the parties to present witnesses, including fact and expert witnesses and any other evidence. We can't restrict the ability of either party to discuss the allegations under investigation or to gather and present relevant evidence while the investigation is going on. We have to provide both sides with the same opportunities to have other people present during any grievance proceeding. We have to provide to a party whose participation is invited or inspected written notice of the time, date, and place of the hearing, the participants in the hearing, the purpose of the hearing, investigative interviews that have been conducted, or other meetings with sufficient time for the party to be able to participate. We have to provide both parties with an equal opportunity to inspect and review any evidence that's been obtained. And prior to completion of the investigative report, we have to send to each side and their advisor, which could be an attorney, remember, if they have an advisor, we have to send them the evidence that is subject to inspection and review. And those parties then have 10 days each, at least 10 days each, to submit a written response which the investigator has to consider prior to completion of the investigative report. And then we have to create an investigative report that fairly summarizes the evidence and provide a copy to each party at least 10 days prior to any hearing for their written, and give them an opportunity to provide a written response. Okay, now, stop and think about this. There's an allegation of sexual harassment that occurs in the school between two students, okay? Your average principal or assistant principal goes to the videotape, finds videotape of some activity occurring under the stairwell. It appears from the videotape to be fairly clear-cut what was going on. The victim was saying no, 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 and trying to fight off the perpetrator. Okay, the perpetrator would not relent and carried out some sexual harassment until the victim broke away and ran up the stairs. Okay. Your first go-to for a principal or assistant principal is what?
10-day suspension,
Followed by
long-term recommendation.
recommendation for long-term suspension. Okay, so you have a 10-day suspension to remove the kid from school with a follow-up recommendation for long-term suspension, and the evidence appears to be irrefutable. Okay, clear and convincing. Okay, now you got to go through this process, and you've got 10 days built in here, 10 days built in there. What happens when the 10-day suspension is up if you've had an emergency removal? And you've got a recommendation for long-term suspension. It doesn't work with this process. So we've got a number of places where the new regulations have a disconnect with our state law dealing with suspensions, okay, that need to be resolved when you consider the board policies. Sandy?
To your point, the third bullet, not restricting the ability of either party to discuss the allegations in the investigation.
Right.
That's
We do that all the time.
right.
Wh-
We want to restrict to
Right.
preserve the integrity of the investigation and not cloud the evidence or.
Exactly, and we tell folks that all the time. When we used to tell folks that all the time. We'd say, you know, as part of this investigation, we don't want you going out and talking to other people because we want to preserve and protect the integrity of the investigation, and we don't want you influencing what they're going to say or having the appearance of influencing what they're going to say by the time we get around to interviewing them. Okay? These regulations specifically restrict us from doing that. Okay? We cannot restrict the ability of either party to conduct their own investigation or go to gather evidence or talk with potential witnesses.
Which gets really sticky in the student versus student situation if the parent of the student who was assaulting the student is now
Allegedly
assaulting, is now going in, trying to do their own investigation, is pulling other kids in. Now you're involving other parents. I mean, this is a whole different investigative process.
Yeah, I said it was a federal regulation. I didn't say it made sense.
Okay.
Okay? But you know, there are some really dicey things in here that, you know, that change the way a lot of investigations have been conducted in the past.
Is there a definition of expert witnesses?
No, expert witnesses don't come in, you know, to this process necessarily.
Seems to be a direct conflict with what law enforcement and what would happen if you were investigating a crime or some kind of allegation outside of the school.
Well, not necessarily, because if you know, if law enforcement are investigating, law enforcement can't tell you, don't talk. Now, they charge you with obstruction of justice if they think you're intimidating a witness or interfering with an investigation, or you can be charged with witness intimidation, okay? But they can't go, you know, if they're investigating murder, they can't tell the alleged murderer's attorney, you can't investigate on your own, or you can't hire a private investigator, or you can't try to gather evidence of witnesses that you can utilize for the defense of your client. And that's basically what's going on here now.
Richard, could you basically say all this impact that we're having here, that this whole change in policy comes from what was occurring on college campuses?
Very much so, Joe.
Yeah.
And that's a good observation. A lot of this does occur to what was happening on college campuses, where colleges were under enormous pressure to put into place investigations and processes and hearing processes that really restricted the ability of an alleged perpetrator to defend themselves.
Well, when you mentioned the 98%, you know, believability of the rape victim, or however you characterize it,
Right.
that tells you enough right there, I think, in terms of the process.
Yeah, exactly. You know, I mean, you know, I could tell you a lot more about that case, but it was It was messy in a lot of ways procedurally. Okay, so now you get around to finally determining responsibility at the end of this process. So the grievance process may, but is not required to provide a hearing. And that's another decision the board's going to have to make in the board policies. Okay, do you get to agree at the end of this investigation, do you get to a hearing, or do you get to a determination that's made by the investigator and town line coordinator? So with or without a hearing, after the district has sent the investigative report to the parties and before reaching a final determination regarding responsibility, here's what we have to do. We have to give each side the opportunity to submit written relevant questions that they want to be asked of any other party or a witness. We have to provide each party with the answers to those questions. We have to allow for additional limited follow-up questions from each side. And in that questioning, or in any questioning about this, questions about a complainant's, that is the alleged victim's, prior sexual behavior or predispositions, sexual predispositions, are only allowed to establish that another person committed the alleged conduct, or if they concern specific incidents of a complainant's prior sexual behavior with the respondent, they're offered to prove consent. Okay.
So again, we're extending the timeline.
We're again extending the timeline, but this last provision also deals with a little bit of a rape shield type focus. It limits the questions you can ask about an alleged victim's sexual activity. Okay, but it does allow specific questions about that activity if the questions are allowed to are intended to show that another person committed the conduct, or to try to prove consent with the alleged perpetrator. Now, keep in mind that we've got other statutes that require hearings for students. For example, long-term suspensions or expulsions for students, or if we suspend an employee without pay or change the terms of conditions of their employment or dismiss them, they're entitled to hearings under our statutes as well. So again, we've got student discipline statutes and we've got employment statutes that would require hearings depending upon what the disposition is under this investigation. All right, determining responsibility. The decision maker cannot be the Title IX coordinator or the investigator. So we've got to have a different person who is the decision maker than the one who was doing the investigating, and the Title IX coordinator, and different from the Title IX coordinator. And the decision maker issues a written determination regarding responsibility. Remember, the burden of proof at all times remains on the school system. The written determination has to be given simultaneously to both parties, and it has to include these things. It has to describe the allegations and describe all of the procedural steps that were taken from the time a formal complaint was initiated through the determination, including all notices that were given to the parties, interviews with parties and witnesses, site visits, that is, we went to check out the area under the stairwell, methods that were used to gather other evidence and any hearings that were held, findings of fact to support the determination, conclusions regarding the application of the code of conduct to the specific facts, and a statement and rationale regarding each allegation that has to include a determination of responsibility, any disciplinary sanctions that we're going to impose on the respondent, the alleged perpetrator, whether any remedies are designed to restore or preserve equal access to the educational activities or programs, and the procedures and permissible bases for either party to appeal. All of that has to be included in the written determination.
So the decision maker really needs to be the superintendent, correct?
That's probably where it's going, yeah. Okay? But that's up to the But that's up to the board. That's another decision to be made in board policy. Nope, the decision maker reviews all of the stuff that was done by the other folks, right? Okay, now.
But also, I mean, you're going to have overlap in the investigator and the decision maker, because common practice or procedure would be, particularly with an employee investigation, would be the superintendent be involved in the investigation.
Not necessarily.
Not necessarily, but in practice, yes.
Well, there's going to be there may be a little overlap, but there's supposed to be independence of the part of the investigator and the decision maker.
Richard, could you appoint an independent board?
You could appoint an independent investigator. You could hire an outside investigator. There are trained Title IX investigators. There are organizations that are right now busily training Title IX investigators. There are organizations that are contracting with outside investigators who are trained and certified Title IX investigators to come in and do Title IX investigations.
So it may give us pause to think about who the Title IX coordinator should be.
It may, yes.
Yeah.
Yes.
Yep. Okay. So let's look at responding to formal complaints. You can have appeals, okay? So we have to offer both sides the opportunity for appeals from a determination regarding responsibility or from a dismissal of a formal complaint or any allegations therein on these bases, okay? They can appeal and say that there was some procedural irregularity that affected the outcome, that there's newly discovered evidence that could affect the outcome, and or that the Title IX personnel, that is the Title IX coordinator, the investigator, or the decision maker, had a conflict of interest or bias that affected the outcome of the matter. So those are all different bases for appeal from the final determination or the dismissal of a formal complaint or any allegation that's contained in the final determination. We can add in our policies, if we want to, additional bases for appeals as long as those are available to both sides. So that's yet another decision that you need to make in the policy adoption process. All right, continue on with the appeals. For any appeal that gets filed, we have to notify the other side. We have to make sure that the decision maker for the appeal is not the same person who made the initial determination. We have to give both sides a reasonable, equal opportunity to submit a written statement in support of or challenging the outcome, and issue a written decision that describes the result of the appeal and the reason for that decision, the rationale for the result, and provide that written decision simultaneously to both parties. All right, now, what about informal resolutions? You've got an allegation, you notify both parties, can you have an informal resolution? No, not unless you've had a formal complaint filed. So this is kind of a weird part of the new regulations. Okay, you can only have an informal resolution after a formal complaint has been filed. We cannot require anybody to participate in an informal resolution process, but we can offer it. It is allowed but not required in all cases except where the complaint involves a student being sexually harassed by an employee. Okay? It can be offered at any time once the formal complaint process has been initiated. And an offer of informal resolution has to include written notice to both parties that says, okay, here's what we're dealing with. It has to describe the allegations, the requirements of the formal process, any rules that would prevent the complainant from bringing the formal complaint again, and any other consequences, including how records will be kept. Okay? So we can have rules that would prevent the complainant from bringing the formal complaint again if they go through the informal resolution process, or we cannot have those rules. All right? Both sides have to voluntarily agree in writing to the informal resolution process before we can go through that. There are non-retaliation provisions that apply throughout this whole process, and this is a little bit interesting, okay? It says, no district or other person may intimidate, threaten, coerce, or discriminate against somebody because that person has made a report or complaint or testified, assisted, or participated or refuse to participate in any manner in an investigation, proceeding, or hearing. So wait, look at that last part. Refuse to participate in an investigation, proceeding, or hearing. Well, what about an employee? Okay, this goes against case law that we've got that says, if an employee is accused of doing something on the job, okay, they're obligated to answer our questions about it. And their failure or refusal to do so can be considered insubordination and grounds for dismissal. But this says they have a right to refuse to participate. Okay? So we got a little bit of a problem there. All right, there are a lot of notice requirements under this new Title IX procedure. First of all, we have to designate one employee to coordinate the efforts to comply with Title IX, and that person has to be referred to as the Title IX coordinator. Okay, so whatever you used to call this person over here, okay, she is now the Title IX coordinator. Okay, okay. All right. The district has to notify any applicants for admission and employment, students, parents, or legal guardians of elementary school students, elementary and secondary school students, and employees of the name or title, the office address, the email address, and telephone number of the employee or employees designated as the Title IX coordinator, and provide notice in everything we do that we don't discriminate on the basis of sex in our education program or activities, and that any inquiries can be referred to the Title IX coordinator or the U.S. Department of Education's Assistant Secretary for Civil Rights, or both. And that non-discrimination statement and the contact information for the Title IX coordinator has to be on our website and in each handbook and catalog.
What if we decided to hire somebody as the Title IX coordinator?
Then you'd have to display their name in every website and catalog. Are you thinking about what I just said a little bit while ago about a certified investigator coming in? That's, the investigator is different from the Title IX coordinator. Okay? All right. All right, training. Training is required for all staff on how to identify and report sexual harassment. Training is required for the Title IX investigators, the decision makers, the coordinators, and the facilitators of an informal resolution to teach them how to be impartial and unbiased and how to objectively evaluate all relevant evidence, including that which could convict or acquit, inculpatory or exculpatory evidence. Okay? So this is, I'm going on a safety training course tomorrow, and what do you think you're going to learn there? All right, record keeping. There are extensive record keeping requirements. We have to maintain for 7 years every report and formal complaint of sexual harassment, and the records that are maintained are the investigative records, disciplinary sanctions, the remedies, the appeals, actions taken, and supportive measures. If a complainant was not provided with supportive measures, then the reasons why have to be documented. We have to document the basis for any conclusion that our response was not deliberately indifferent. We have to document that we have taken measures that are designed to restore and preserve equal access to the education program or activity for both the complainant and the respondent. And we have to maintain a record of all training materials that were used for the Title IX coordinators, the investigators, decision makers, and anybody who facilitates an informal resolution process. And those must also be maintained and published on the website. Okay, on our website. Okay? All right, anybody have any questions?
I'm still trying to get past the fact that if there's a complaint and the student leaves the school,
Yep.
that means they can just go to another school with that behavior and check.
Right. If there's a complaint and the person leaves the school and goes someplace else, they can go with that behavior unchecked. Depends on what there are possibilities that we would dismiss that complaint, okay? And if they left before the resolution of the complaint, that's when we'd have a dismissal. Okay, so they would have left before any disciplinary action that was taken that would be a long-term suspension or expulsion. All right? Unless it was an emergency removal. So, yeah, they could leave and go to another district or another school.
Well, there's potential criminal prosecution as well.
Potential criminal prosecution, yes. Yep. This is a huge mouthful. Okay, these regulations are enormous. As I mentioned, there were the OCR's got over 2,000 pages of explanations for this new regulation.
Well, I think, again, it was done basically to combat a perceived disadvantage to the respondent.
That's correct. There's an awful lot of that was the reaction to what was perceived as, the pendulum had tipped way far, it was the Obama, the Trump administration has defined this as a centering of a recentering or a reorienting of dealing with Title IX investigations. But in the course of doing that, the process and the procedures and the protections that are built in are substantial, as you can see.
Richard,
requires a lot of process.
Were the previous Obama regulations from the OCR also applicable to K through 12 schools?
Yes,
Okay.
yeah. But there was a lot more emphasis on colleges and universities in terms of enforcement. That was where the big focus was.
So one thing the board may want to consider for the public that's listening, we have a board policy committee. Obviously, we've got first read tonight, and it sounds like an extensive amount of work needs to be done with the policy committee, and we may want to schedule a time for the day when the packet meeting, when we've got that scheduled, and maybe extend that time and have Rich or someone from his staff maybe on the phone for questions. So as we start to plan for that meeting, I think it's September
Yeah,
2nd.
I would endorse that as well, and whether it's on the phone or here.
Okay.
It's a lot to deal with.
Yeah, that sounds like a plan, yeah, good idea.
Yeah.
So,
Now, one thing I'd like to ask you to all be thinking about is the standard of proof that you're going to go with, whether it's the preponderance of the evidence, that is just a greater weight, or 50% plus a feather, or clear and convincing evidence, which is in between the preponderance and proof beyond a reasonable doubt. What's that?
I said clear and convincing is video.
Well, it can be clear and convincing without being so far as, live and caught on tape, because you don't have live and caught on tape an awful lot.
Why are we going to review the new policies tonight? Why are there going to be so many changes at the committee meeting?
Well, it's just up for first read tonight so that you can get it ready to go to committee and then come back and be ready for adoption on second read. Because keep in mind, these new regulations are in effect now.
Right, I
So-
understand that, but when the first reading, sounds like to me, when y'all go back to the committee, there's going to be a lot of changes.
Yeah.
there'll be
So
some
then you'll-
changes. And
you'll-
Yep.
then we'd be expected to approve it on the second read, which it really would be another, almost first read
Yeah.
to make the changes.
Yeah, you're not going to have to approve it when it comes to you for second reading. I mean, you could say, look, this is too much. We need to,
Yeah.
go through this and study it again. But at least this gets it on the table,
Okay.
first read.
What point though are we,
It's in effect right now.
Well,
we don't have policies.
the new regs are in effect. We've got our existing policies in effect. And, we're kind of running, like everybody else is right now. You're not the only school system in America that, didn't rush to adopt these in the middle of a pandemic, in between,
Yes.
the end of May and now. So, the good news is that you're on remote learning and you're not likely to have a whole lot of cases come up right now.
That's true.
That buys us a little time.
Yep. And if there
Sure.
are reports of any allegations that occurred prior to August 14th, those are
They don't-
not covered under the new regs.
Okay.
And
Did you
Rich
read
is
them?
providing a trainer for our
I read them.
administrators tomorrow at 1 PM.
For the administrators tomorrow.
Rich
Yeah.
is training our administrators,
Good.
same kind of training tomorrow.
Yeah. How will we go about training all those other people that have to be trained, like substitute teachers?
Well, I think we've
And-
got to get the modules that come from Schwartz and Shaw, and then we
Okay.
would set up
You do
a
it- okay. They
process
can
to
just
be
do it on
able to
the computer.
train
Okay.
all the different stakeholders who need the training.
It's just like they do for sports. You go online and the coaches have to do it.
Mhm. But the concussion,
And
yeah,
all. You go
Yeah.
online and you log in and they have a record of it.
yeah, all of that, okay.
That would probably be an annual training event also?
It would be whenever you get a new employee, and then you could do annual training as well, refresher training.
Annual training?
You don't have to do annual training, no, but you have to make sure that all of your
All of your
employees are
employees.
trained.
And we could add it to our annual policy sign-off process where employees come back, they're expected to read and know the policies, and then on an annual basis, they're signing off acknowledgement
Right.
that they've read
Yeah.
each of the policies, and that list this year is what, 20?
Yeah, but you got two things here. One is you want to have evidence that they signed off that they were trained, but
Right, right.
but the other thing is you want to make sure that they're actually being trained.
Right.
Effectively trained. Yeah. Okay,
Thank you, Rich.
Sure there'll be more questions.
All right.
I'm sure there will be. It is.
okay. All right, I want to make sure what the target is, where everybody knows it is.
Get the target, there we go. All right, thank you, Rich. Interesting presentation, for sure. Item 7 on our agenda is the consideration and approval of proposed policies, which we have now established that we will not be approving those tonight, but we will be doing a little brief summary. Is that correct, Ms. Kinsel?
Very brief.
Okay.
I'm
I just
exhausted.
threw that word in there, I know. I think we're all on overload at this point.
Well, again, I think the policies that are listed on the agenda this evening, again, were all prompted by
Right.
the new federal laws related to Title IX. So the new policies that were listed, again, were required. I'm glad that we have Rich at our disposal to be able to help us to glean a deeper understanding of the implications of those policies, and that we're going to back up and we're going to have some additional time to be able to fill in some of those gaps over the next couple of weeks. And I think that'll make for better policy all the way around. In addition to the policies that were listed as new policies related to Title IX, we had a few additional policies that were recommended by the School Boards Association because of the references between the Title IX new policies and existing policies. And in referencing and researching the policies that were recommended with the policies we have in our policy book, some of these policies weren't even on the books. Again, each time I get into policies, it becomes a treasure hunt. But we're cleaning it up and we're making progress
you
as we
are.
go along. So
Absolutely.
thanks for your patience with that. So we have a couple of the policies were recommended that would be new to Dare County Schools, and they were also included, but again, they're all affiliated with Title IX. We also had some revised policies. Again, most of these are due to references to the grievance policy that will essentially be rescinded once we get to the finish line on the new policies. But there were also some conflicts with the new policies that are coming out from the School Boards Association, whether it be with the new numbering that they assign to them. They either conflicted with policies we had on the books we want to maintain, but the numbers were going to be overlapping. And in some cases, the numbers were fine, but the titles were going to be very confusing. So again, my goal when we're looking at these policies is to try to tightly align with the School Boards Association, because it makes it easier when we go to, when we get revisions, that we can go in and we can find the policy without having to tease and pull apart two different policies or overlap. So those were listed. We had, again, the renaming of a policy. One, let's see. Okay, the policy related to student behaviors. This is not necessarily directly related to the Title IX policies, But when we went through that, the communication of that policy is more than, we added some language in there to talk about how the removal of the regulations piece was actually the handbook that we create every year that has all of the policies that are related to student behaviors. The guide that we create, the handbook, also includes consequences and gives a range of consequences, and that's really used to communicate fully how those policies are going to be implemented if they're in fact broken. So we've pulled out in the regulations that portion of the regulations. One, it's hard to keep up to date. So we added the language in the policy to say that this will be communicated through a direct posting of the code of conduct, and that the principals will be responsible for providing that, as well as any additional rules of conduct at the school annually. And so that part will help us to make the connection between what we're removing and helping to make sure that we are meeting our burden of communicating the code of conduct. Let's see. Again, at the bottom, we had some new regulations. One new regulation is directly related to the Title IX sexual harassment, and it just separates the definitions, and many of which Rich went over this evening. The revised regulations, though, many of them have to do with, well, the code of conduct I've just went over, but many of the others have to do with, like, visitors in school, the regulations for community use of school facilities, and the use of school facilities just in general by the community. We felt it was important to add some language there about potential restrictions that may go into effect because of a governor's executive order, or having guidance from the North Carolina Department of Health and Human Services, such as the pandemic that we're experiencing now, and holding people accountable for those regulations when they come into the building. So those have been included in the regulations. And again, regulations are for information only, so those things can go into effect at this point. But we'll hold off on the new one until we come back, because it won't make sense by itself. All right.
All right.
Okay. That's all.
Thank you, Ms. Kinzel.
Thank you.
Is there any other business? Backs to everybody. Okay, no other business. I appreciate everybody coming tonight and being here, spending your whole afternoon here. So thank you. A motion to adjourn by Ms. Lawler, a second by Mr. Twitty. All in favor, please say aye. Any